Chongo, can you please hand over to the legal representative? To Mr. Zwane and to Mr. Van Eden. Yes, you are.
Schedule 5 by location. The city has brought it under the attention of council that the board is not sitting here tomorrow, and they risk running they run the risk that if we don't finish tomorrow or today, there is going to be a problem. So I don't know how the defense wants to proceed at this, but the state is ready to proceed with the schedule 5 applications, and that is the
we are also ready. We are going to be short because we'll be just reading the sworn affidavits into record.
Okay, no problem. Let's continue.
Thank you, Worship. On behalf of accused number 1, Matshela Koko, I will continue to read the following sworn affidavit into record. I, the undersigned, do hereby declare as follows that I'm an applicant and the accused in this matter. The facts contained herein falls within my personal knowledge and are both true and correct. I've been advised by my legal representative that the charges brought against me fall within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, wherein referred to as the Criminal Procedure Act. I confirm that where the charges brought against me falls within the ambit of Schedule 5 of the Criminal Procedure Act, the onus rests on me to convince the Honourable Court that the terms of Section 60, subsection 11B of the Criminal Procedure Act, that it is in the interest of justice that I be released on bail, or in terms of Section 60, paragraph 11, subsection 11, paragraph A of the Criminal Procedure Act, that there are exceptional circumstances which in the interest of justice permit my release on bail. I confirm that my rights have been explained to me and that I've got a right to remain silent and that I do not disclose any information which may incriminate me. I've been advised that in terms of Section 60, sub 11, paragraph B of the Criminal Procedure Act, I have the honors to disclose to the Honourable Court whether I have got previous convictions or pending cases. I confirm further that I've been advised that should I disclose any false information concerning my previous convictions or pending cases and it later be found to be false, I can be sentenced to a period of not exceeding 2 years or imprisonment or be liable to a fine not exceeding 40,000 rand. In respect of previous convictions, I place the following on record. I have no previous conviction. In respect of pending cases, I place the following on record. I have no other pending cases. I was arrested on the 27th of October 2022 in my house at 683 Sarandon Estate, 4 Ways. I'm an adult male residing at 683 Sarandon Estate. I am conducting business in Zimbabwe and other neighboring countries. From time to time, I'll have to travel to these countries in business trips. I am a husband and a father of 5. This includes 2 stepchildren, and one of the children is a minor. I am unemployed, and other countries that I conduct business in includes Namibia, Botswana, and Zambia. I've got the following financial information. I have a bond of about 45,000 rand and a car installment of about 30,000 rand. I have school fees for about 13,000 rand and housekeeping for water and lights for about 15,000 rand. I have the following assets. A house in Sarandon worth about 4 million rands and a house in Harley Sport worth about 3.2 million rands, both which are bonded. I am a South African citizen and I possess a valid South African identity document and I do have a passport. I have traveled outside the borders of South Africa. I am told that the state does not oppose my bail, my release on bail. I am healthy and under no medication. I am not a flight risk and I undertake to stand my trial to attend to court as and when is expected of me. I have made no threats towards anyone involved and I have received no threats, and my safety will not be compromised should I be released on bail. The community will not be disgruntled should I be released on bail, and I cannot think of any reason why my release on bail will affect the public peace and order. I cannot, of any reason, see why my release on bail would negatively influence the criminal procedure and more specifically bail legislation. I, at all material times, provided the police with the correct information which they required of me, and I fully cooperated. I will be severely prejudiced should I not be released on bail. In the preparation of my trial, I will lose my work and income, will not be able to comply with financial obligations. I am not part of any gang or any syndicate. No specific person or group of persons' safety will be threatened should I be released on bail. I will make an amount of 50,000 rand available for bail, and I can not forfeit the amount to the state by not abiding to the bail conditions. I undertake to abide by the reasonable bail conditions should the Honorable Court release me on bail. I therefore submit that I've discharged the honors resting upon me to satisfy the Honorable Court that there are exceptional circumstances which in the interest of justice permit my release on bail. Alternatively, that I've shown the interest of justice do permit, it does not require my further detention. This is a sworn statement, sworn and signed in Middleburg on the 27th of October. Now, Your Worship, these are our submissions. Your Worship, we submit that based on the evidence that has been tendered by the affidavit on behalf of accused number 1, it will only be in the interest of justice that accused number 1 be allowed, Your Worship, to be released on bail. Further, Your Worship, that he must be allowed to continue conducting businesses in the countries in which he has stipulated that he conducts business in. And it appears from the affidavit, Your Worship, that he conducts business in Zimbabwe, Mozambique, not Mozambique, Zambia, and Botswana, Your Worship. Now, our submission is that we believe that the South African government does have an extradition treaty with all these countries, and as a result, accused number 1, as and when needed to be in court, will be here. Further conditions can be placed, Your Worship, upon the accused, such conditions being that whenever the accused has to leave the country, they have to report to the investigating officer, and when they come back into the country, they also do the same. And the court can place any other reasonable conditions, Your Worship, that will make it possible for my client that while out on bail, which I believe that this court will agree with me, he becomes able to conduct all these businesses while attending court. Your Worship, also, I will also remind the court of the case of Shaban in the question of considering the amount of bail, that whenever the court pronounces bail, it must pronounce bail in such a manner that it makes it possible for the accused person to, number 1, pay the bail, number 2, as a result of the accused having paid the bail, the accused coming to court. Now, the purpose of bail, Your Worship, must not be misconstrued, because these are accused persons. These are people that have not been found guilty of any crime. It's the state that is alleging that they are guilty of these crimes. So the court will have to balance the interest of justice, Your Worship, because at a later stage it may happen that there was actually no crime. So in taking all of that into account, the court has to look at the circumstances of the accused which have been placed before court, the interest of justice as well, Your Worship, which I submit that before this honorable court, they permit for the release of my client on bail. Your Worship, it is common cause that the investigation has been long and my client has never left the country. If at any point my client intended to abscond, having to answer to these charges, my client would have left the country. But Your Worship, as it is common cause that my client was arrested today in his house, it shows that my client is a South African citizen who owes his allegiance to this country and will, as and when needed to attend to court, he will attend to court and observe the bail conditions. Your Worship, I submit that a proper case has been made, and therefore the court may make a reasonable pronunciation on bail and make necessary conditions insofar as they are in the interest of justice and the administration of justice, as the court presentation.
Yes, can I just request to have a quick insight of the statement before it is handed up to the court?
Koko, please stand. Do you confirm the correctness of the statement that was read out on your behalf to be true and correct?
I do.
And you confirm that you have signed the said statement, affidavit?
I do.
Bail statement received at the time.
As it is supposed to.
Excuse, you may be seated.
Court pleases, which I think it's my turn for case number 2. Which I'm going to adduce evidence by means of affidavit. We're not going to leave any evidence. Can I proceed? Thank
Yes.
you. So affidavit, I on the signed Francis Tolle, here declare on the oath as follows. I'm the applicant in above mentioned matter, an adult male, age 50, with the following personal particulars and background. My identification number is 720707548247. My date of birth is the 7th of July 1972. I'm a South African citizen. I have a valid passport, and the SAP took this morning when they arrested me at home. Previous travel or residence in foreign countries, there's no residence in foreign countries, got no relatives outside the borders of South Africa, and no assets outside the borders of South Africa. Personal background, I was born in Brits Northwest Province. Schooling, I obtained grade 12 at high school in Brits, and in tertiary and other training, I've got a diploma in mechanical engineering that I got at TUT. I've also got an MBA at Renaissance. Work history, I'm self-employed, and at the moment I'm the CEO of Dida Occupational Health. My address is 378 Lombardi Estate via Zasta, where I've lived the past 4.5 years. Your worship, the accused has also been arrested here at this address this morning. I'm married since 1999. My wife's initials and Dita's GWP Setole. Got 3 dependents, 3 children that I still maintain with my wife. They're 22, 21, and 12 years of age. As I've already stated, I'm self-employed, and my income is approximately net salary 35,000 per month. Other sources of income at this stage is none. Assets, I've got a house number 11, The Woods in Wapad, Rand in Pretoria. Worship, availability of funds for bail is, the court will notice that I've indicated 100,000 here. That is available, but during the break I also had a discussion with family members. There is another 50,000 available if the court deems or it fit for a higher amount, your worship. So there is amount up to 150 available. I've got no previous convictions, no pending cases. My date of arrest was this morning, the 27th of October 2022, an offence that I've charged with fraud and corruption. My tenant plea is I'm going to plead not guilty. My defences, I will disclose my defence during the trial. I confirm that this application falls under as a Schedule 5 bail application, your worship. Regarding 64A2E, danger to the public or individual safety, I'm not a danger to the public and did not commit offences previously. The likelihood of evasion of trial, I stay at my home address for the past 4.5 years. The South African police took my passport this morning at my house, and my attorney had previous meetings with the IO regarding this case. Section 64C, interference with witnesses. I don't know the name of state witness, and I have never interfered with persons regarding the case. I understand that the investigation has been finalized. Regarding jeopardy 64D, the function of criminal justice system, I'm first offender and I gave cooperation to the SAP. In 64E, there are no circumstances which may lead to the undermining of the public order, your worship. Other relevant factors, I'm aware that this is an ongoing investigation, this case, for a long time, and I've never tried to flee the country. Bishop, this has been signed by the accused this morning, and it has been commissioned here at the court by the SAP. Bishop, I would like to hand this up as exhibit. We're not going to lead other evidence, Your Worship. This will then address the court later. It's the court Jesus, Your Worship. This is a case for accused number 2. I will just then address the court.
Okay.
I don't know whether I should do it after the state.
Yes.
Thank you.
Mr. Sitole, do you confirm that the statement that was read out on your behalf is true and correct? And that you also signed the said statement? Statement received, Exhibit B. You may be seated.
If it pleases the court, Your Worship, if I may then proceed with reading into the record an affidavit prepared in respect of accused number 12, Your Worship, as it pleases the court. Your Worship, I, the undersigned Walton Sabatwalo Seswa, declare under oath as follows. I'm the accused in this matter. The content of this affidavit is within my personal knowledge and understanding, and unless it appears from this affidavit to be the contrary and to the best of my knowledge, true and correct. I'm competent to dispose of this affidavit and have locus stand out to lodge this application. I'm advised that the charges brought against me fall within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977. I confirm that whereas the charges brought against me fall within Schedule 5 of the Criminal Procedure Act 51 of 1977, that the onus rests upon me to convince the Honourable Court that it is in the interest of justice that I be released on bail. I further confirm that my rights have been explained to me and that I have the right to remain silent. I further confirm that I do not have to disclose any information which may incriminate me. I'm advised that I have the onus to disclose to the Honourable Court whether I have previous convictions and or pending cases and or whether any protection order in terms of the Domestic Violence Act has been granted or application pending in respect of me. I am further advised and I herewith confirm that I have been advised that it is punishable should I disclose false information and should it later be found that I did not fully disclose all information in respect of my previous convictions or pending cases to the Honourable Court. I could be prosecuted and upon a verdict of guilty be sentenced to 40,000 rand or 2 years imprisonment. I have no previous convictions, I have no pending cases against me, and there are no domestic violence protection orders against me, nor are any applications in terms thereof pending or to be launched against me. I was arrested in respect of this matter at my residence on 27 October 2022, being today's date. The above-mentioned charges apparently took place at Middelburg. The state witness's identity is not known to me, but I undertake in any way not to make contact with any state witnesses and not to interfere with the investigation. In respect of my personal circumstances, I place the following on record, that I've been in custody since this morning from approximately 5:40. I am resident at 23 Pitchley Estate, Pitchley Road, Bryanston. The aforementioned address belongs to me and is bonded with Nedbank. I have been resident at the aforementioned address since 2017. I consider the aforementioned address as my permanent place of residence. I am married and am the sole breadwinner for my family. I have 6 children for whom I maintain respectively ranging from 5 to 25 years. 4 are in school, 3 at Brescia House. Notwithstanding that I maintain my wife and children, I further maintain my elderly mother, who is a widow in Limpopo and who suffers with arthritis. I'm a businessman and am self-employed, employing 40 employees. I have an income of approximately 100,000 rand per month. I've been in service since 2002. I have the following assets: my residence, which is bonded by approximately 1 million rand, and 3 vehicles which are financed, being a Jaguar, Porsche and Mercedes-Benz vehicles. My business as well. I have close family ties with my family. I have the following financial obligations: the bond, school fees in respect of my 4 minor children and 2 major children who are dependent on me, as well as my wife. I'm a and elderly mother. I'm a South African citizen. I do have a passport and do not have any other travelling documents, and undertake to deliver the above mentioned to the investigating officer if so requested. My family is resident at my residence as aforesaid. I am not a flight risk and undertake to stand my trial and to attend court where and when expected of me. I have made no threats towards any person involved with this case, nor will I commit any acts of domestic violence. I received no threats and my safety would not be compromised should the above honourable court release me on bail. The community will not be disgruntled should I be released on bail. I cannot think of any reason why my release on bail would negatively affect the public peace and order. I cannot think of any reason why my release on bail would negatively influence the criminal procedure and more specifically bail legislation. As far as I know, I have given my cooperation to the investigating officer, more specifically in respect of my personal information. I'm advised that the investigation in these kinds of matters could take up to several years, and I would be severely prejudiced for the under-mentioned reasons should I not be released on bail. I will be prejudiced in the preparation of my trial. I will lose my work or income and will not be able to maintain my family independence. I will not be able to comply with my financial responsibilities and will lose my assets. I will be deprived of my liberty under circumstances where the case against me have not been properly investigated. The state's case against me lacks substance, that I have a valid defense in law against the charges brought against me, that I'm not linked with the offences and deny any involvement with the offences. It is likely that the bond on my property may be foreclosed on and me and my family rendered homeless. My business will be closed and approximately 40 employees will lose their jobs. School fees in relation to my children need to be paid, particularly given the time of year where accounts and amounts need to be paid. If I am unable to pay as a result of being incarcerated, they may be expelled. My elderly mother will lose her only means of support and treatment will be frustrated. I'm advised that the state does not oppose bail for the following reasons. I'm not a flight risk and will not contravene any of the issues or obligations in terms of Section 64 of the Criminal Procedure Act 51 of 1977. I'm not a member of any gang or syndicate. No specific person or group of persons' safety will be threatened should I be released on bail. I will make a reasonable amount of bail available and propose an amount of 40,000 rand available in respect of bail. I cannot afford to forfeit the amount to the state by not abiding to the bail conditions. In respect of the merits of the charges against me, I place the following on record: that I intend to plead not guilty to the charges, that at this stage neither I nor my legal representatives have had sight of the charge sheet and been able to ascertain exactly what charges have been preferred against me. Having said that, I have been advised that the charges are in terms of precca have been laid against me, exceeding an amount of 500,000 rand. In due course, copies of the charge sheet will be obtained and copies of the docket, and I, together with my legal representatives, will deal with the charges against me, as I do not believe I have committed any offence. I undertake to abide by any reasonable conditions of bail should the above honourable court release me on bail, including the following: the tendering of any travel documentation to the state, which in any event has already been handed in to the state authorities. In the interest of justice, whereas the onus rests upon me to convince the honourable court that it is in the interest of justice that I be released on bail, I humbly request the honourable court to take the above, together with the undermentioned circumstances, into account upon the consideration of my application, and to resolve in my favour that the said circumstances permit, in the interest of justice, that I be released on bail. I have at all times cooperated with the authorities. I am not a flight risk and undertake to attend every court hearing. I have firm ties to the community. Me and my family could be rendered homeless and lose property if unable to pay debts and obligations. My business will close down and 40 people will lose their jobs, as I'm the only one who can run it. I'm the sole breadwinner in my household, which comprises of me, my wife, and 6 children, who are all financially dependent on me, including paying medical aids. My minor children may be expelled and not allowed to return to their schools due to non-payment, and at this time of the year, it may not be possible to make alternative arrangements for free public schooling for them, gravely affecting their right to education. I have taken the above honourable court into my trust by the disclosure of the information and request that the honourable court resolve in my favour that I have, on a balance of probabilities, discharged myself of the onus to convince the honourable court that it is in the interest of justice that I be released on bail. Therefore, I humbly pray that the honourable court release me on bail on such conditions as the honourable court may deem fit. I confirm that the above information is true and correct. I confirm that I am advised that the information herein contained, except for the information in respect of previous convictions, may be used against me during trial. This done and signed in Middelburg on this day of 27 October 2022 and commissioned, Your Worship. Your Worship, if it pleases the court, I would respectfully request that this affidavit be handed up as an exhibit. Your Worship, insofar as any argument is concerned, I would perhaps reserve that to ascertain what exactly the state's position is in relation to this bail application, as it pleases the court.
Mr. Seswai? Seswai? prove you must swap
No,
positions.
Your Worship, the case is correct. I think the legal counsel went out of order, but Mr. Siswa is the last one.
Okay. This is why you confirm that the correctness of the statement that was read out on your behalf, and you further confirm that you have signed the said statement. Okay, Exhibit C.
As it pleases the court.
As it pleases the court, Your Worship, may I proceed to read affidavit on behalf of accused number 8.
8. Okay, continue.
I, unassigned, Tagoore Mukwena, do hereby make oath and state that I am a 52-year-old adult male and South African citizen residing at 4 Longmore Road, Bryan Street, 70. I am accused number 8 insulting under case number 413/07/2022, pending before this honorable court. I attest hereto solely in anticipation of this application to be released on bail. I have been advised that the charges preferred against me fall under the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977, and as such, I am required to adduce evidence which satisfies this honorable court that the interest of justice permits my release. I was arrested shortly after 8:30 this morning, 27 October 2022, by Captain Smith in the presence of another member of South African Police Services and my legal representatives. Captain Smith informed me that he has a warrant of arrest for me and as such was placing me under arrest on the following charges. Count 3, contravention of Section 13, subsection 1A of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Alternatively, contravention of Section 12, subsection 1A and Section 3, subsection 1A of Act 12 of 2004. Count 15 and 16, fraud. Captain Smith, however, was unable to explain to me or to my legal representatives what the nature and details of the charges entailed, and advised that he was merely executing the warrant for my arrest, and that Colonel Pete Duplessis was in fact the investigating officer in the matter. I attach here to a copy of J50, that is the warrant of arrest that was served on me this morning, marked TOM1. I further attach here to a copy of annexure to J50 listing the charges handed to me by Captain Smith upon my arrest and marked TOM2. I fully cooperated with police this morning and intend to continue rendering the necessary cooperation insofar as it is relevant. Captain Smith also advised that the state was not opposed to me being released on bail, but I, however, would have to apply to be released on bail. To this end, I have managed to secure 100,000 rands in lieu of payment for bail. I dispute the charges as I have never conducted myself in a manner that contravenes the legislation manifesting the basis for the charges preferred against me. I'm an honest businessman who has always conducted himself above reproach. As such, I intend to stand my trial and defend these charges to the hilt. Under interest of justice, there is absolutely no likelihood whatsoever that my release on bail will endanger the safety of the public or any person, nor is there any likelihood that I would commit Schedule 1 offense. There is no likelihood whatsoever of me evading to stand my trial or attempting to evade to stand my trial. I intend to attend all court proceedings to defend myself and have no desire to evade justice. I am currently unemployed and a former chairman of Liaho Pty Ltd, engaged in consulting engineering entity, which entity ceased to trade in March 2020. I'm also a director of several entities which are presently dormant. I previously served as an advisor to various political heads in government until recently. I am married with 4 children, respectively aged 24, 10, 5 and 1. I have been resident at my current address since 2013. I own property, although it is still bonded, and the property is valued at 12 million. I am the sole breadwinner of my family. As stated above, I dispute the charges against me and intend to defend same to the hilt. I have no family or friends abroad and have handed both my personal passport and my diplomatic passport to Captain Smith earlier this morning. I further have no assets or any financial means outside of that which I have in the Republic. I do not know any of the witnesses, nor has any evidential disclosure been made to me. As such, there is further no remote likelihood that I will influence or intimidate any witnesses or attempt to do so. Neither is there any likelihood of me concealing any evidence nor attempting to do so. In this regard, I have not displayed a degree of violence towards anyone, neither have I threatened anyone with violence, nor have I displayed or harbored any resentment against anyone. There is also no likelihood of that my release on bail would undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including bail system. Lastly, there is also no likelihood that my release on bail will disturb the public order nor undermine the public peace and or security. In conclusion, I have no previous convictions, nor do I have any pending cases. I submit to this honorable court that all circumstances described above individually and cumulatively demonstrate that it will be in the best interest of justice for this honorable court to release me on bail. As such, I tender an amount of 100,000 rands in lieu of bail, along with any bail conditions that the court may impose on me. I know and understand the contents of this affidavit. I have no objections in taking the prescribed oath. I consider the prescribed oath as binding on my conscience. The affidavit, Your Worship, was deposed today and was commissioned today. Your Worship, may I beg leave to hand over the statement?
Any protection orders against them in terms of the Domestic Violence Act and the Protection Against Harassment Act, or whether there are any pending applications to that effect. Can you please take instructions from the client, please? It also not, it doesn't appear from the statements of accused Mr. Sitole and Mr. Koko.
Your Worship, I'm instructed that the accused doesn't have any of such funds. And no any pending.
Okay. Mr. Mokwena? Do you confirm the correctness of the statement that was read out on your behalf? And do you further confirm that you do not have any protection orders, either in terms of the Domestic Violence Act or in terms of the Protection Against Harassment Act? Okay. Well, there's no pending applications against you. It's received for Exhibit G. Can you please take instructions from your client as well, and as well as with regard to whether there are any protection orders against you?
Your worship, the instructions are that there's none pending
Okay.
and none granted.
Okay.
The same here, none, your worship. No pending motion.
Is that the case for the applicants?
As it pleases the court, yes, I may address the motion or accuse part.
May I just adjourn for 2 minutes?
Sorry,
All right. All right.
Let's go on record. Madam Prosecutor. Yes.
Thank you, Worship. You should serve us a statement from the investigating officer. In it, it refers to the names and the details of the minor children. For their privacy, the state will not read it out, but it is for the court's purpose in this. As a business report, bail affidavit in respect of accused 1, 2, 8, and 12. I, the undersigned, Petrus Janus Duplessis, do hereby make under oath and say as follows. A. Introduction. I'm a Lieutenant Colonel in service of the SA Police with personal number 0406 5565, 57 years old, male. I currently perform duties as a detective at the Investigating Director, Linton House, 570, Gresham Street, Brooklyn Bridge, Brooklyn, Victoria. My cell phone number is 02 778 and the email address where I can be contacted on is wschreiber@npa.gov.za. I am with Captain W. Schreiber, the investigating officer of Frampton Gas 413/07 of 2017. The following offences are under investigation. 2.1, corruption and contraventions of section 13, sub 1 sub A and 13.2 A regular sections 1, 2, 24, 25, 26, 3 and 4 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and in the alternative contraventions of section 3 and or section 10, federal sections 1, 2, 24, 25, 26, 3 and 4 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, corruption and contravention of section 12(1)A and 12(2)A, read of sections 1 to 24, 25, 26, 3 and 4 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and in the alternative, contravention of sections 3 and or section 10, read of sections 1 to 24, 25, 26, 3 and 4 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and 2.3, money laundering in contravention of section 4, 5 and 6 of POCA as amended, and fraud. Paragraph 3. The four accused in this matter currently before the court is Matshela Koko, Shlepeka Franz Tole, Sabu Mokwena, and Watson Siswa. 4. The structure of the affidavit will be as follows. 4.1. Summary of charges and schedule applicable to each of the respective accused bail application. 4.2. Background of the investigation. 4.3. Charges against each accused, their personal circumstances, and factors relevant for the consideration of bail. 4.4. Other relevant factors. 4.5. Conclusion. B. Summary of charges and applicable to schedule for respective bail applications. The table here undersets out the accused, a short summary of the charges, and which schedule is applicable for the respective accused bail application. With the leave of the court, I will not read this out. Save time. Attached to the charge sheet is a copy of the draft charge sheet with the main counts and the alternatives in two. C. Background of the investigation. 7.1. Eskom is a public company duly incorporated in terms of the Eskom Conversion Act, Act 13 of 2001, and the Companies Law of South Africa with registration number 2002/015527/30, and having a share capital held by the Government of the Republic of South Africa. 7.2. Eskom is classified as an organ of state in accordance with the provision of Section 239 of the Constitution of the Republic of South Africa, Act 108 of 1996. 7.3. Eskom is also incorporated as a state-owned entity in terms of the Companies Act, Act 71 of 2008, and a major public entity in terms of Schedule 2 of the Public Finance Management Act, Act 1 of 1999. 7.4. Procurement of goods and services by Eskom is regulated by Section 217 of the Constitution of the Republic of South Africa, the Public Finance Management Act, and the Preferential Procurement Policy Framework, Act 5 of 2000. In terms hereof, Eskom is legally obliged to create and maintain a procurement system enabling the contracting of goods and services in a manner that is fair, equitable, transparent, competitive, and cost-effective. 8.1. Since 2002, Eskom undertook two large capital projects, namely Medupi and Kusile Power Station building projects. 8.2. On 13 October 2009, the Board of Directors Tender Committee, the BTC, approved a mandate to conclude a contract with Eskom S&E for the provision of the control and instrumentation system for the Power Island and balance of plant, as well as training simulator for the Medupi and Kusile Power Station, under a fleet agreement to the value of 2.1 billion, excluding VAT and other costs, over a period of 6 years. 8.3. During 2012 to 2014, Eskom started having performance issues at Medupi and Kusile, and their contract was eventually cancelled in March 2015. On 8.4, on 9 April 2014, the Eskom Board Building Program Review Committee mandated the strategy to place early works order with three potential alternative suppliers being ABB, MEL, and Siemens as a risk mitigating strategy to mitigate the perceived risk of Eskom not performing. MEL later withdrew, and the only two competitors were ABB and Siemens. 8.5. The early works order was meant for the early design work on Medupi Unit 4 and Kusile Unit 1. 8.9. Subsequent to Eskom's non-performance and the early works order contracts, a closed tender process was initiated to source an alternative C&I contractor. 8.10. On the 24th of February 2015, the Board of Directors Tender Committee approved a request to conclude a contract with ABB. The letter of acceptance was issued on 13 March 2015, and the final contract signed on the 29th of April 2015. 8.12. The total value of this contract was 2.5 billion rand. 9. The investigation emanated from the irregularities and the procurement process which were not fair, equitable, transparent, competitive and cost-effective in the award of the CNI contract to ABB, and the subsequent appointment of their subcontractors Liago EPC Pty Ltd, Liago Consolidated Pty Ltd, represented by Mokoena, and Impulse International Pty Ltd, represented at the time by the late Ferguson Patha as the director, and during the period 31 March 2016 to 20 September 2016, K. Choma as the director. Paragraph 10. Investigations revealed that Koko used his influence and position to influence the award of the CNI contract to ABB, in that he 10.1 engaged in a general corrupt relationship with ABB employees, Brugman, Bip, and Wolf, and Mokoena during the period 2014 to 2019. 10.2. ABB subsequently received preferential treatment and information which Siemens, the main competitor, did not receive. The procurement process was therefore not transparent and competitive. Paragraph 11.1. Mokoena's company was awarded a contract to provide services during the early works audit phase in the amount of 5.6 million rand. His company, Liago EPC, was then known as Liago Strategic Services Pty Ltd, as a subcontractor of ABB, was awarded a contract in the amount of 96 million rand exclusive of that to provide the skill development and industrialization portion of the CNI contract. 11.2. An out of the ordinary 9.6 million advance payment was made by ABB to Mokoena, which Dietrich Wolf, a Section 204 witness, stated was meant for Koko. 11.3. Evidence revealed that the relationship between Koko and Mokoena broke down and no further contracts were awarded to Mokoena or any of the companies he represented. Role plays in the ABB Impulse Eskom Impulse contracts, paragraph 12.1. Impulse International was represented by Ferguson Patha, the director of the company, and for the period 31 March 2016 to 20 September 2016 by K. Choma, Koko's stepdaughter. Father passed away on 27 June 2021. 12.2. Koko used his influence and position to influence the awarding of Impulse as a subcontractor of ABB after his fallout with Mokoena. K. Choma, the stepdaughter of Koko, was appointed as the director at Impulse on 31 March 2016 and resigned on 20 September 2016. 12.4. K. Choma retained her interest in Impulse via the Makoni Trust as follows. 12.5. The Makoni Trust with reference number IT 2000216/2016 was registered on 7 July 2016. 12.5. On 21 September 2016, the day after she resigned as the director of Impulse, she transferred her 25% shareholding in Impulse to Makoni Trust, where she was registered as a trustee and a beneficiary as set out in the diagram hereunder. Paragraph 13. Impulse was appointed as a subcontractor of ABB, although the company did not qualify to be appointed in terms of the ABB supply chain process. 40. Wolf in his affidavit explains the involvement of Impulse as a subcontractor of ABB as follows. 14.1. Sunil Vip, an ABB employee who also played an instrumental role in the award of the contract to ABB and Koko, would agree upon a target price for variation orders. 14.2. Vip will then supply the ABB team working on the VO proposals, the variation order proposals, with the target price and the opening bid price. 14.3. Vernon Pillay, an ABB employee, then liaised with Parker and ensured that Impulse would tailor the bid to ABB in such a way that the proposal to Eskom would have a semblance of legitimacy. 14.4. Pillay would then ensure that the same occurred with ABB's proposal to Eskom. 14.5. Negotiations between ABB and Eskom officials who were not in the know regarding the Impulse scheme would take place on site, but at some stage people involved in the scheme would enter the scene and ensure that the variation order would then be issued at a price close to the initial target price. 14.6. Sitoli was the project director at Kusile at the time and signed off on the variation orders. 15. The Impulse scheme was successfully implemented in regard to the following. 15.1. Unit 1 acceleration variation order, contract value of 249 million rand. 15.2. Unit 2 trunk cabling variation order, contract value at 300 million rand. 15.3. Unit 2 acceleration contract value at 289 million rand. 15.4. Demobilization variation contract value at 179 million rand. 16.6. This led to an overpayment by Eskom for work done by ABB, where Impulse was subcontracted. Impulse received a total of 449 million from ABB as part of the subcontracting agreement, 17.1. Impulse also contracted to Eskom directly in 10 contracts. Impulse received a total of 295 million rand from these contracts. 17.2. The two contracts relevant to this investigation is the following. 17.2.1. Contract 4600058330 for the planning of turbine centerline activities through quality work packages and SAP. The value of this contract and the modifications thereof was 95 million rand. And 17.2.2, contract 4600060205, Easter weekend emergency contract in the amount of 49 million rand, was awarded as a result of an emergency declared by Sitole for the supply of additional workers, and the second contract 4600061009 on the first declared emergency in the amount of 99 million, which was awarded to Impulse on a sole source basis as they were already on site. 17.3. Evidence point to the fact that no emergency existed to justify the circumvention of the normal procurement process. 17.4. The preference to Impulse is evidenced by the extraordinary approval decisions followed and the manipulation of procurement and governance processes. Structures and cloud funds to facilitate payment of gratification and money laundering. Paragraph 18. Impulse made payments to the benefit of Koko and his direct family members. 38 million was paid to Ikwakiwa Investments as follows. 18.1, 23 million into Ikwakiwa Investments Standard Bank account with number 203032934. This account was opened and administered by Kutsia. 18.2, 15 million into Ikwakiwa's FNB account with number 6263231698. This account was opened on 13 September 2016. 18.3, Kate Choma was the director of the company from 23 March 2016. Paragraph 19. Money from the accounts were then paid to the following accounts to the benefit of Koko and his family members. 19.1. Turnkey Finishings, Pty Ltd. M.E. Koko was the director of the company and Koko's wife. 19.2. High Echelon or Dominion Capital Pty Ltd. Business account and home loan account. M.E. Koko is also the director of this company. Throne Concepts, Pty Ltd. T. Choma is the director of the company and Koko's stepdaughter. 19.4. Tatu Choma Bank and Concepts, Standard Bank account 0215450014. T. Choma is Koko's stepdaughter. Paragraph 20.1. From the accounts mentioned in paragraphs 18 and 19, payments were made to M.E. Koko's Property Development on Ad 10987 Middelburg Township. High Echelon Trading Pty Ltd. currently owns 26 properties under the sectional title SS3 Baitka. This is a luxury property development in Middelburg. 20.2. Payments were also made to luxurious family holiday trips to Mauritius, France, and Colorado. 20.3. Existing entities and their bank accounts and newly established entities such as the Mafoni Trust and bank account of the Ikwakiwa Investments Throne Concepts were put in place to facilitate the payment of gratification and to have a likely have the effect of concealing or disguising the nature, source, location, disposition, or movement of the said property or the ownership thereof, or any interest which anyone may have in respect thereof. 20.2. These structures were put in place on advice of Kutsia. Francie Torres Rowan, Eskom Impulse Contracts. Paragraph 21.1. Vitoli, the project director, also used his influence and position to influence the award of the variation orders to ABB and the appointment of Impulse on the Easter Weekend Emergency Contract. 21.2. The amount of 3.1 million was paid to Ntesa Surf Pty Ltd's account, and then in a series of transactions paid to benefit of Sitori. D. Accused 1, Matshela Koko, charges, personal circumstances and factors relevant for the consideration of bail. Paragraph 22. Corporate charge of the following offences: 22.1, 5 counts of corruption; 22.2, 1 count of money laundering in contravention of Section 4 of the Prevention of Organised Crime Act; 22.3, 1 count of fraud. Paragraph 23.1, the accused ID number is 690309535087. He was born on 9 March 1969. He is a South African citizen. He is married to M.E. Koko on 9 December 2009. He has 4 children. 24.1, the accused was previously employed at Eskom. 24.2, he resigned from Eskom on 16 February 2018. The day of his disciplinary hearing was scheduled. At the time of his resignation, he held the position of interim chief executive officer. 24.3, at the time of his resignation, his salary was approximately 138,000 per month, excluding yearly bonuses. 25.4, I do not know where the accused is currently employed. 26.1, the accused is currently residing at 683 Sarrington Estate, Cedar Avenue West, Galway, Johannesburg. This address has been confirmed. 26.2, accused is a co-owner of this property under Title B T-7470/2005 B928430/1992. 26.3, the property was bought for 6.5 million rand. 27.1, the accused has a valid passport number with number A04728891M. The passport is valid until 19 May 2025. 27.2, the accused has a second passport with number M00303483, which is valid until 12 June 2029. 27.2, the accused regularly traveled overseas when he was employed at Eskom in his official capacity. 27.3, the accused also traveled overseas for holidays to Dubai, France, and Mauritius. 28. From January 2018 to date, he traveled outside of South Africa on 31 occasions to the following destinations: 28.1 Zimbabwe, 28.2 Dubai, 28.3 Addis Ababa, 28.4 Uganda, 28.5 Nairobi, 28.6 Tanzania, 28.7 Hong Kong, 28.8 Mauritius. 29, the accused does not have any previous convictions. 30, the following movable assets is registered in his name. 30.1, Lexus LX570, registration number FA02NXGP. 30.2, Mercedes-Benz C207, registration number FR78SL.
Let me go check the wash.
Absolutely that way.
It's back.
This affidavit, no. Well, allemaal kan er heel duidelijk af zien.
Anders kan ik niet meer af.
Yeah. Authority.
But she's not done. Now she would say that she went for something more than 100. I know the judge will grant something more than 100. So it's clear. Look, I argued for 20,000. And he paid 70,000. But let's see it from him. As long as they can afford. That's what we want.
No, relax. No,
You can transfer. You can transfer. I spoke to my lady, so I spoke to them. So they'll give you a reference on the account details. You can transfer. Yeah. So at least that arrangement.
I established that because I was being concerned. So I established it.
I even forgot to tell you because I was away. So thanks for that. Yeah. Let's wait. Just make the applications. What they need to do is just to report how much that is important. Otherwise, I don't foresee this is very because mistakes Sure. I don't think those conversations will remain confidential. They must. They must. They must. these things. That's how they spy on us. Yeah, so let's hear what they say. Good. So, yes, we were going to talk to the magistrate. Sitting in some so that's why we said, people are saying to the court staff, guys, let's do this tomorrow. Which actually helped us even because they won't sleep in the I think it's this. It's quite thick. Right?
Hey, taxi.
No, affidavit is not yeah. The affidavit itself. What is it? What are they at time to be investigating? Till first of all, this morning, now they will be ready. But yeah, it's so they say. Is it very practicing? Yeah. Is it? They want no, I know. Last I went to Zwana. Some years ago, I went to the center. What's this? Woodmead Office Park. Yeah, I know it. And I think then I was still waiting for the June to connect some matter.
We're going to start.
All right, Sumani and Ella. Before we continue, I just need to confirm something from the court clerk as to the recordings. The audible. Let us continue.
As a piece of support, Your Worship, I was at the movable assets. Safe to say there are 4 vehicles registered on the accused name. 31. Your Worship, for privacy purposes then as well, the state will not read out the property's addresses. 31.1. A property purchased for 6.5 million on 27 March 2015. 31.2, a property purchased for 2 million rand. 31.3, a property purchased on 20 July 2005 for 300,000 rand. The property is now fully developed. 32, the accused has the following business interest. 30.1, from media reports, I have learned that the accused is a company, Matshela Energy, Pty Ltd, with its South African headquarters situated at the Pivot Block E, Monte Casino Boulevard, 4 West Johannesburg. 30.2, Matshela Energy Pty Ltd was allegedly awarded a license to set up a power plant by the Zimbabwean Energy Regulatory Authority in Rwanda, Matabeleland in South Zimbabwe. This is allegedly a $250 million project. 32.1. The accused, Bishop, I see the paragraph numbering is wrong, but I will continue as it is. 32.1. The accused is charged with corruption, money laundering, and fraud in that he accepted gratification from ABB and Import International Pty Ltd to use his position to influence and manipulate the award of the C&I contracts in favor of ABB, the onboarding of Leago EPC Pty Ltd, and Leago consolidated as subcontractors to ABB, and later the onboarding of Impulse International Pty Ltd as a subcontractor of ABB, and to then inflate contract prices and or to give Impulse International Pty Ltd preferential treatment as a subcontractor of ABB. 32.2. If the accused is convicted, a minimum sentence of 15 years imprisonment in terms of Section 51 of Act 105 of 1998 will be applicable to several of the charges he faced. 33. The accused was employed at Eskom as the interim chief executive officer when he committed some of the offences as specified in the charge sheet. As a result, most of the state witnesses are known to him, which increases the risk that he may attempt to contact the witnesses and try to interfere with them. 34.1. Due to the nature of the charges and possible sentences the accused faced, if convicted and his extensive business interest in Zimbabwe, there is a likelihood that if the accused is released on bail, he will attempt to evade his trial. 34.2. The likelihood of the accused to evade his trial can be limited by setting a substantial amount of bail and strict bail conditions. I respectfully suggest that the bail amount of 500,000 should be set, taking into account his personal circumstances as well as the gravity of the charges he faced and the possible sentence if he is convicted. 34.3. The accused must hand over his passport to me. The accused may not apply for a new travel document. 34.4. The accused must report to his nearest police station once per week between 8 in the morning and 4 in the afternoon. The nearest police station to his residential address is Douglasdale Police Station. 34.5. The accused may not enter any port of entry except of South Africa except for a domestic flight within South Africa, in which case he should provide me in writing with a copy of his flight particulars of accommodation, the period of the anticipated travel, and a landline number at the travel destination a week before the anticipated travel, on W. Schreiber at npa.gov.za. 34.6. The accused must inform me of any changes of his address that is residential on W. Schreiber at npa.gov.za. 34.7. The accused may not contact the witness as per Annex PJDP1, Year 2 directly or indirectly, and might not make or cause their identities to become public. In respect of accused 2, Shlepeka Francis Tole charges personal circumstances and factors relevant for the consideration of bail. 35.1, Sitole is charged of the following offences: 35.1, 2 counts of corruption; 35.2, 1 count of money laundering; and 35.3, 1 count of fraud. As the pleases court, that is a typing error, it should be 2 counts of fraud. 36.1, the accused ID number is 7207075482087. He was born on 7 July 1972. He's a South African citizen. He is married to Kodrigetse Wilhelmina Priscilla Sitole on 7 January 2000. He has 3 children. 37.1, the accused was previously employed by Eskom. 37.2, he resigned from Eskom on 1 April 2018. At the time of his resignation, he held the position of Project Director proceeding. 37.3, at the time of his appointment as Project Director, his salary was 2 million rand per annum, excluding yearly bonuses. 37.4, according to information, he is currently employed at Idiri Consulting. 38.1, the accused is currently residing at a property in Pretoria East. The property is registered in the name of Idiri Consulting Services, CC. 38.2, the address is confirmed. 39.1, the accused has a passport with number A01993047. The passport expired on 31 October 2021. 39.2, the accused has a valid passport with number A08311837, which was issued on 4 February 2019 and will expire on 3 February 2029. 40. From March 2018 to date, he travelled outside of South Africa on 13 occasions to the following destinations: 40.1 Maputo, 40.2 Kenya, 40.3 Lesotho, 40.4 London, 40.5 Tanzania, 40.6 Hong Kong, 40.7 Dubai, 40.8 Abidjan, 40.9 Zambia, 40.10 Botswana, and 40.11 Malawi. 41. The accused does not have any previous convictions. 42. The accused has the following immovable properties: a property in Pretoria. The selling price in 2010 was 526,000 rand. 42.2. The second property in Pretoria. The following movable assets is registered in his name. 42.3. A road dog trailer, off-road camping trailer. 43. The accused holds the following directorships in the following entities: 43.1. Mediates Medical Supplies Pty Ltd. 43.2. Idiri On-Site Clinics Pty Ltd. 43.3. Idiri Occupational Health Pty Ltd. 43.4. Idiri Innovation and Technology. 43.5. Matimba Power Pty Ltd. 44.1. The accused is charged of corruption, money laundering and fraud in that he accepted gratification from Impulse International to use his position to influence the award of contracts to Impulse International, a service provider to Eskom directly and as a subcontractor of ABB, and to then inflate contract prices and or to give Impulse preferential treatment as a subcontractor of ABB. 44.2. If the accused is convicted, a minimum sentence of 15 years imprisonment in terms of Section 51 of Act 105 of 1998 will be applicable to several of the charges he faced. 45. The accused was employed at Eskom as the project director at Kusile Power Station. This was the most senior position at the Kusile Power Station when he committed the offences as specified in the charge sheet. As a result, most of the state witnesses are known to him, which increases the risk that he may attempt to contact the witnesses and try to interfere with them. 46. I do not have an objection against bail being set for the accused. 46.1. I respectfully suggest that bail be set in the amount of 300,000 rand. taking into account his personal circumstances as well as the gravity of the charges he faced and the possible sentence if he is convicted. 46.2. To limit the likelihood that the accused will evade his trial, he must hand over his expired and valid passports to me. The accused may not apply for new travel documents. 46.3. Accused must inform me of any change of his address and document number at 28.gov.za. 46.4. The accused may not contact the witnesses as per Annex PJP 1 hereto directly or indirectly and may not make or cause their identities to become public. Accused 8. Tabo Owen Mokoena. 47. The accused is charged with the following schedule offences. 47.1. One count of corruption. Yushma, just have a second. The plea is support and 47.2, 2 counts of fraud. 48. The accused ID number is 7009195761089. He was born on 19 September 1970. He is a South African citizen. He is married to Mambuzo Winifred Mashlangeni Mokoena. He has 3 children. 49. The accused was previously employed by the State Security Agency. I do not know where the accused is currently employed. 50. The accused is currently residing in Johannesburg. This address has been confirmed. 51.1. The accused is a valid passport with number M001655594. This passport was issued on 19 November 2015 and will expire on 18 November 2025. 52.2. The accused has a second passport with number D00020491. The passport was issued on 14 September 2019 and will expire on 3 September 2024. This is a diplomatic passport. 52.3. During the accused's arrest, he voluntarily provided his passport with number M001655594 on request of the arresting officer, Colonel Smith. 52.4. He denied having a diplomatic passport. He provided Colonel Smith with a contact number to confirm that the passport was not in possession of the accused. 52.5. This conversation took place in the presence of the accused's legal representative, Advocate Sean Abrams. 52.6. Colonel Smith insisted that the information in his possession indicate that the accused was in possession of the passport. The accused then provided the passport. 53. From March 2018 to date, he traveled outside of South Africa on 9 occasions and visited the following destinations: 53.1, Mozambique; 53.2, Zambia; 53.3, Paris; 53.4, Sao Paulo; 53.6, 53.5, Hong Kong; 53.6, London; 53.7, Mauritius; 53.8, Dubai; 53.9, Seychelles; 53.10, Munich. 54. The accused does not have any previous convictions. 55. The following movable assets is registered in his name, and there are 5 vehicles listed. 56. The accused has the following immovable property. 56.1. A property in Cornwall Road that was purchased in 2013 for 5.2 million rand. 56.2. The accused is the director of Lialco Consolidated P2 Ltd. The company is the owner of Farm 506, Wachtenbekkieskop, portion 151 of portion 85 in the registration division of Kungwini local municipality. The property was bought in June 2015 for 4.4 million rand. 57. The accused has interest in the following entities: 57.1, Afrisum Construction; 57.2, Afrisum Holdings; 57.3, Afrisum Intelligent Transport Systems; 57.4, Afrisum Locomotives; 57.5, Afrisum Resources; 57.6, Bengaplex; 57.7, Center of Research and Advocacy Public Entities; 57.8, Climate Awareness Campaign; 57.9, Dusty Gold Trading 28; 57.10, Electricity Distribution Industry Holdings; 57.11, Gans South Africa; 57.12, Hartebeeste Kom Edelgesteentes Explorasie en Mynbou; 57.13 harte Eskom minerasie, explorasie in mynbou. 57.14 HMF Swiss Meat Management. 57.15 Kumu Diamonds. 57.15 Kwanzaa Steel Corporation. 57.16 Liago Consolidated. 57.17 Liago EPC. 57.18 Liago Group. 57.19 Liago Group. 57.20 Liago Lifestyle. 58.1 the accused is a trustee of the Kuma Trust with registration number IT 9351 of 2004. The particulars of his two co-trustees are listed. 59.1 the accused is charged of corruption, fraud, in that he accepted gratification from ABB for his role in the tender process in the award of the CNI contract in favour of ABB, and as an award for transmitting important information during the closed tender process to ABB. The onboarding of Liago EPC, P2Y Ltd and Liago Consolidated as subcontractors to ABB were given preferential treatment as subcontractors of ABB. 59.2 if the accused is convicted, a minimum sentence of 15 years imprisonment in terms of Section 51 of Act 105 of 1998 will be applicable to several of the charges he faced. 60.1 I respectfully suggest that bail in the amount of 300,000 should be set, taking into account his personal circumstances as well as the gravity of the charges he faced and the possible sentence if he is convicted. 60.2 to limit the likelihood that the accused will evade his trial, he must hand over his expired and valid passports to me, and he may not apply for new travel documents. 60.3 accused must inform me of any change of his residential address on W. Schreiber at NPA.gov.za. 60.4 the accused may not contact the witnesses as per Annexure 3JDP1 year to directly or indirectly, and may not make or cause identities to become public. Accused 12 Watson Siswa. Siswa is charged with the following offences: 1 count of corruption. The accused ID number is 760423535884. He was born on 23 April 1976. He is a South African citizen. He is married to Manakedi Ida Siswa. He has 3 children. Paragraph 63, the accused was previously employed by Impulse. 64, the accused is currently residing in Bryanston, Sandton. This address has been confirmed. 65, the accused has a valid passport with number A05716501. The passport is valid until 29 November 2026. 66. In the past few years, he travelled outside South Africa on 2 occasions to the following destinations: 66.1 Dubai, 66.2 Swaziland. 67. The accused has a previous conviction for theft, shoplifting, dated 22 January 1998. Sandton Case 551/12/. I think that is a typing error. It should be 1997. 68. The following movable assets is registered in his name. 3 vehicles are listed. 69. The accused has the following business interests: 69.1 Power of 8 B2 Ltd, 69.2 Siswa Branding and Marketing, 69.3 Siswa Energy, 69.4 Siswa Engineering, 69.5 Vijayakaya Foundation. 70.1 the accused is charged of corruption in that he is an employee of Impulse International, paid or facilitated the payment of gratification to Koko. 70.2 if the accused is convicted, a minimum sentence of 15 years imprisonment in terms of Section 51 of Act 105 of 1998 will be applicable to several of the charges. 71.1 I respectfully suggest a bail in the amount of 300,000 rand, taking into account his personal circumstances as well as the gravity of the charges he faced and the possible sentence if he is convicted. 71.2 to limit the likelihood that the accused will evade his trial, he must hand over his expired and valid passports to me, and he may not apply for new travel documents. 71.3 the accused must inform me of any changes of his address to W. Schreiber at npa.gov.za. 71.4 the accused may not contact the witnesses as per Annexure 3JP1 due to directly or indirectly may not make or cause identities to become public. 72 general. The investigation in this matter is not complete. I anticipate that the information obtained from the search and seizure operation that was done at the premises of the accused and the premises of Koko and Kutsia this morning, which must be accessed and analyzed, and a report compiled on the findings may take at least 3 months. Conclusion 73.1. I have no objection against bail for accused 1, who is charged with a Schedule 5 offence in the amount of 500,000 rand with bail conditions. 73.2. I have no objection against bail for accused 2, 8, and 12, who is charged with Schedule 5 offences in the amount of 300,000 rand with bail conditions. Please report it was signed by Lieutenant Colonel du Plessis and Public Commission this morning. Please report now and it up. And shake. Please report that is the case for the state.
Bail affidavit of Petrus Johannes du Plessis is received as Exhibit E. The defense of the applicants have received copies of the bail affidavit.
No, Your Worship.
Your Worship, we have copies, we will pass them on.
Your Worship, if I may, just in relation to accused number 12, Your Worship, the state made mention of a previous conviction which we're not aware of, and I have a feeling that my client isn't aware of that either. Your Worship, in the circumstances, may I just quickly approach my client to get an instruction on that in the interim, as it pleases the court.
What is the position?
Your Worship, I've taken instructions on that aspect, Your Worship. Indeed, the accused was convicted in 1997 or 1998, Your Worship. Pardon, Your Worship?
98.
97, 98, Your Worship, and he was under the impression that that was automatically expunged as per the Criminal Procedure Act, Your Worship. And in fact, Your Worship, he thought that it had so-called prescribed, if I may use the term applicable in this case, Your Worship, and he respectfully apologizes to the Honourable Court. He didn't mean to mislead anyone, Your Worship. He simply paid a fine of approximately 500 rand, Your Worship, and assumed that that was the end of it, Your Worship, and that there wouldn't essentially be a record so far down the line, Your Worship, that being approximately 25 years, 24, 25 years down the line, Your Worship. So
it hasn't been expunged, so it still exists.
Yes, Your Worship. Technically it does, Your Worship, and of course we will attend to the necessary in order for that to be expunged, Your Worship. He was under the impression that it was, mistakenly so, Your Worship.
I think the only instance where it is not taken into consideration, it is when it is for sentencing purposes, where the court should not consider it since the lapse of 10 years. That's the only reason. But for any other purposes, it still stands.
Your Worship, in the circumstances, I would respectfully perhaps request the Honourable Court, in light of this, Your Worship, to perhaps amplify on the statement and make that a particular formally place that on the record, Your Worship, with Your Worship, it's something to be considered, Your Worship. If I may beg leave in order to do so, Your Worship, and draft a very quick statement in that regard. Thank you, Your Worship. I will amend it accordingly.
The issue, Madam Prosecutor, the issue with regard to the diplomatic passport of one of the applicants.
Yes, Your Worship, the state has no knowledge of how the accused came into possession of the diplomatic passport or why he has one, but it is now in possession of the state.
It's in possession of the state?
Yes.
Okay.
Your Worship, if I may address you on that for accused number 8, the issue of the diplomatic passport. As we indicated in the affidavit for the accused, that he was an advisor of various political heads of government, so he had to travel with them out of the country. That is the basis for him to be in possession of such passport. As we got this.
Yes, yes, Javier.
Your Worship, may I just quickly approach my client just to ensure that he's comfortable with this, Your Worship? Your Worship, if I may then just proceed to read the amended paragraph 4.4 to the accused 12's statement, Your Worship. It says, I have one previous conviction of theft in 1997 or 1998 in Sandton. I was sentenced to a fine of 500 Rand. I sincerely apologize to the above honorable court for not having disclosed same, as I mistakenly believed that same was expunged. I apologize to the honorable court for this indiscretion, which was not malicious or in any way intended to mislead the honorable court. Your Worship, and that, Your Worship, is the case for accused 12 in relation to bail, as it pleases the court.
that the case for the state?
That's correct. You should decide in just a case.
Ms. Warner, do you have further submissions to make?
Of course,
In
Your Worship.
addition to the earlier ones.
Thanks, Your Worship. Your Worship, in address in favor of accused number 1, Mr. Koko, Your Worship, it is common cause that the court in bail proceedings is sui generis, and that is undisputed, Your Worship. Now, taking it further, Your Worship, these are our submissions. The court is not called today to make a finding on fact. However, whatever finding it makes it on speculation of the future based on proven facts. So, Your Worship, it's common cause between the parties that what is in dispute is the amount of bail to be set. The state has proposed through the affidavit of the investigating officer an amount of 500,000 rand. Your Worship, I do submit that that constitutes an unreasonable amount of money. And as I've referred the court earlier on to the matter of Shoban, I have quoted it into a record. It was made very, very clear, Your Worship, that whenever an amount of bail is set, it must be set in such a way that the accused person is able to afford it. It must not amount to a refusal of bail. The facts that have been, which I submit are proven facts before court, makes it abundantly clear that accused number 1 is unemployed. The accused number 1 is conducting business as it appears in the affidavits that were read in court. Your Worship, I would like to submit it to this honorable court that we've made out a proper case that proves that it is in the interest of justice that Mr. Matshela Koko is released on bail. And Your Worship, as it appeared, if I may say, as it appears in our affidavit, we are offering an amount of 50,000 rand as an amount for bail. And what is also common cause, Your Worship, is that the court must also bear in mind that when the accused was arrested, he was arrested in his home. And at the back of its mind, the court must also ask itself that if Mr. Koko intended for any other reason to evade or abscond this trial, he would not have been found. But, Your Worship, he was found in his home, and that is where he was arrested. It is also common cause before court that is conducting business in other countries. He has been getting in and out of South Africa conducting his business. So that alone, Your Worship, should tell this honorable court that Mr. Koko does not have intentions of absconding trial. Over and above that, Your Worship, I would like to just refer the court to the matter of R versus Duplessis, 1957 decision, volume 4, SA 463, Vet. The court said there, the court ought to determine what amount will compel the accused in the circumstances to arrive at a trial rather than lose the bail money. And Your Worship, I'd also want to refer this honorable court to the matter of Chopane, S versus Chopane, 1990, volume 1, SA 239, where the court correctly said the following, that the important breakthrough for the protection of the bail rights of an accused stresses the duty of prosecutors and magistrates to guard against unnecessary detention of the accused. Now, what does that say, Your Worship? It says that while we are here in court, we must take into account all the relevant factors of the matter. The court must put itself in a position where it assesses the interest of justice and the rights of the accused, which is Mr. Matshela Koko. And then the main question, Your Worship, is if the court wants to ensure that Mr. Matshela Koko comes here on the next occasion, what should it do? It must set a proper bail amount. And we submit, Your Worship, that an amount of 500,000 rand is not reasonable under the circumstances. In fact, it amounts to a refusal of bail. Your Worship, I submit before this honorable court, Your Worship, that we've made out a proper case, and we submit that an amount of 50,000 rand is a reasonable amount of money, which can compel Mr. Koko to attend court. Further and above, Your Worship, that there's an interesting question that the court must also consider, because from listening to the
employed, but he has managed to raise an amount of 100,000 Your Worship, and we submit that that amount is fair and reasonable under the circumstances of accused number 8, Your Worship. As it pleases the court, Your Worship.
Your Worship, if I may proceed just in relation to accused number 12, Your Worship. Your Worship, as has been stated by the state, Your Worship, they are not opposed to bail in relation to accused number 12, Your Worship, and the fact is that there is no evidence that has been put forward in relation to accused number 12, insofar as the state is concerned, demonstrating why it would not be in the interest of justice or countering the averments made by accused number 12 in his application for bail, Your Worship. Indeed, and I reiterate what my learned colleagues have mentioned in relation to their submissions. Of course, a real bone of contention does appear to be the amount that has been suggested by the state, Your Worship. Your Worship, the amount, and I would respectfully submit in accused number 12 in particular, is quite excessive, Your Worship. The fact of the matter is that he does earn a monthly income of approximately 100,000 Rand. He's proposed a 40,000 Rand bail, Your Worship. It's 40% of his monthly income. The point of bail being set, Your Worship, is not to punish. It is not to essentially put a bar to a person's liberty, Your Worship. The fact of the matter is that as the state is preferred, and unlike perhaps the other accused in this matter, Your Worship, there's only one count of corruption being preferred at this stage, as far as I can tell, in relation to accused number 12, juxtaposed with the other accused, Your Worship. There is no amount which has been set to that value of corruption, Your Worship. In essence, Your Worship, the state's case is, especially insofar as accused number 12 is concerned, is entirely set or based on hearsay evidence at the end of the day, Your Worship. This is simply an investigating officer who hasn't really demonstrated on what basis accused number 12 is linked to all of this, other than saying that he's an employee of Impulse, Your Worship, which, well, from what has been submitted in our affidavit, Your Worship, is clearly not the case. So, Your Worship, as I would respectfully reiterate the proposal which has been set in relation to accused number 12, and that bail be set at 40,000 Rand. It is not an unreasonable amount in the circumstances, Your Worship. Alternatively, Your Worship, I leave that the determination of an amount in the hands of the Honourable Court in that regard, and in relation to any other conditions which haven't been proposed, as far as, if I recall correctly, in relation to accused number 12. So simply, Your Worship, the bail be set at a particular amount. And Your Worship, unless there are any other issues or concerns that Your Worship has at this stage, Your Worship, that would be the case for accused 12's bail application, Your Worship, as it pleases the court.
As it is, Your Worship, it is correct that bail should be individualized, that bail is not a punishment, it is not an indication of the accused's guilt or innocence, but its intention is to secure the attendance of the accused at court and ensure that justice can be done without interference or hindrance to the police, the prosecution, and the witnesses. Your Worship, starting with accused 1.
Can you start with accused 12?
Sorry, Your Worship?
Can you start with accused 12?
The court wants to start well.
The court was informed that it's only facing one count.
That is correct, Your Worship. If I can just... That is correct, Your Worship. Your Worship, the count 11 is at a value of 38 million rand.
What is the
38 million. Yes, Your Worship. No, I apologize. It can't be 38. It must be higher. Your Worship, the contract at the value, at the heart of that contract is worth 98 million rand with Rotec, between Eskom and Rotec.
98 to 95 million.
That's correct, Your Worship. The bail affidavit was a typing error.
And for, I see this, and for the agency contract to secure the services.
Yes, Your Worship, it's two different contracts.
The value of 3.6 million. Those are the values.
Yes, Your Worship. For the accused, it was offered that the accused lacks substance, that the evidence is based on hearsay, but it is a bail application. Hearsay is admissible. Just as the affidavit presented on behalf of the accused is hearsay. There was no corroboration on behalf of the accused. And the strength of the state's case cannot be faulted without any contradiction or any contradictory evidence or information by the defense. That is for the, at the end of the day, for the trial court to make a decision on the strength of the case. Bishop, that was in regard my comments to accused number 12. Bishop, with regard to accused number 8, Mr. Mokoena, Bishop, it is not correct what he stated in his bail application that at all times he assisted or corroborated with police. It is correct that he was arrested at 8:30. If the court looks at the statements of the other accused, they were all arrested at 6 o'clock in the morning. The reason being, Mr. Mokoena refused to open the gate for the police. And by the time his legal advisor, Mr. Sean Abrams, arrived, the police was planning to break down the gate to access it, to access the property. Then also we have the issue of the diplomatic passport, where the accused point blank lied to the police officers. Your Worship, it's submitted on behalf of the state that we cannot take the accused at his word if he says, I will attend. He says he's unemployed. But he can afford to brief an advocate at the drop of a hat in the morning. The state is certain that he can afford the suggested amount of bail. Your Worship, just on that note of Advocate Abrams, the state did inform Advocate Abrams that it objects to him being present in this matter as he was the NDPP when this matter was presented at the NPA under his guidance. Your Worship, that is in relation to Mr. Mokoena. In relationship to Mr. Sitole, Your Worship, let me just get back to Mr. Mokoena. Your Worship, the diplomatic passport. The state does not know why the accused has a diplomatic passport. Yes, he might have been an advisor. He's not an advisor anymore. He should have handed it back, not tried to hide it from the police. Accused number 2, Sitole, Mr. Sitole. Your Worship, the state confirms that the accused was cooperative with the police this morning, that he did not resist or give them any problems. But the state also submits that the charges that the accused faced is serious and the bail amount suggested is appropriate if one looks at the position he held at Eskom and the influence that he wielded at Kusile. Your Worship, with regard to accused number 1, Your Worship, the state submits that accused 1 was not open with this court or took this court into its confidence. On the one part of the bail application, the accused says, I'm unemployed. On the other hand, I have business interests outside the country. You cannot be unemployed and have business interests at the same time. You can be self-employed. But the accused also didn't inform this court the nature of his business interests and that it's at the value of 250 million US dollars, which roughly, if you take the rand-dollar exchange rate at 17 rand, is 4.2 billion rand. The accused did not disclose this. And this is way more than the value that we're talking about, the corruption and fraud and money laundering involving Eskom and Kusile. Nothing prevents the accused from leaving and not returning. The fact that he was woken this morning in his bed by the police does not show he was flightless. It shows the state can plan and execute a plan without anybody knowing. You shouldn't be credited for what the state did wrong this morning. Yes, and if one has a look at the charges, the accused was not an innocent bystander. He laundered money. He was the puppet master in this entire scheme. And for his role, he and his family received a lot of money and luxurious holidays. Here should a further aspect that the accused one also did not take the court into consideration. On behalf of the accused wife and his two stepdaughters, it was argued they can only afford 20,000 rand bail. They've already paid their 70,000 rand out. If we look at what they are facing, and they paid 70,000 rand, 50,000 rand with respect is a joke for what the accused did to Eskom, to Kusile, and to this country. Yes, Your Worship. And we should show to the public that we are serious of keeping our accused in South Africa, keeping them to stand trial, and to stop them from interfering with our witnesses. During the break, Mr. Ndao approached me and said he is the attorney for accused number 1. Now that is very problematic for the state, because Mr. Ndao also represents one of the state witnesses who the state interviewed in terms of Section 28 of the NPA Act. Now, if Mr. Koko is using the same attorney as a state witness, how am I going to guarantee the safety of my witnesses, but for stringent bail conditions and an amount that the accused cannot afford to lose? Your Worship, and then in respect of all the accused, they submit that the public would not be outraged if they're given bail at a low amount. The public is not involved in this matter. Your Worship, it is now 18 minutes past 6. We have several media houses and a packed gallery in court. When last did the court, the commercial crime court, have a packed gallery in the morning? Never mind at 18 minutes past 6 in the evening. Your Worship, even the court personnel is still here. Even the people in the cash office said they will wait until 7 o'clock to assist this matter. This shows the interest and the investment of this public.
But reminder, the disabled court would look here.
So, but that's load shedding and load shedding is out of the court. That is the control of the state, except if the court wants to hear me on anything else. No, Your Worship, that was my final point. If the public interest in this matter cannot be underestimated as it is put.
Any reply from legal questions?
Sorry, Worship, I just would like to put on record a gratification. I just received information from the state. The gratification that we received on the 2 corruption counts is the amount of 3.1 million. I just would like to put that on record too. That's the amount of gratification on the count.